This is the Clear Money Talk podcast, offering up creative solutions for your retirement future through education, choice, transparency, and empathy. Now, your host, CEO and founder of Clear Financial Partners, Tim Clairmont, and co-host, Tyler Andrews.
Hello, and welcome. Welcome to Clear Money Talk. My name is Tim Clairmont, CEO and founder of Clear Financial Partners, and I'm here, as always, with our wondrous co-host, Mr. Tyler Andrews.
Thank you, Tim. It's good to be on the podcast like normal. What if it wasn't called Clear Money Talk? What if it was like,
I don't know,
semi-incomprehensible money talk?
Awesome two guys talking about money.
Two guys talking about money things.
That'd be a thing. That's a really long podcast.
That would be.
Awesome two guys talking about money. But
If there was
we could go with that.
Is there an opposite day? You know, there's like a national holiday for everything. It's like National Donut Day, National Pie Day. Is there like a national opposite day? And if there was, what would we do on that podcast day?
It would be like, I don't know.
What's the opposite of Clear Money Talk?
I don't know, like muddy. Like maybe like dirty money talk.
Like,
I don't know.
I
That
don't
doesn't
like
feel
that.
right.
No,
I
it
just
doesn't.
think, no.
We just would avoid that day. We
would skip that day. That's not a day we would record on.
No.
So anyway, I hope you're all having a great time, enjoying whatever it is that you're doing at this particular moment, whether you're enjoying us on YouTube or whether you're listening to us on your radio or podcast device as chosen. Happy to be here and provide insight on whatever this random question is that I have no idea, as always.
Oh, yeah.
So before I do, let's see what we're going to be talking about today.
All right. Topic of the day, are you paying the price for procrastinating on your estate plan?
Ooh, okay. All right. This will be interesting. So are you paying the price for procrastinating on your estate plan? That almost sounds like Sally sells seashells now by the seashore kind of thing.
Say it five times fast.
Yeah. Are you paying the price for procrastinating on your estate plan? Are you paying the price for procrastinating on your estate plan?
Of course you're going to nail it.
Okay, that's fine. I just need to practice it a couple times. Okay,
that's good.
So are you paying the price for procrastinating on your estate plan? That is the question. And I guess the answer, I try to be as black and white and clear as possible whenever we can be on Clear Money Talk. And of course the answer is well, it depends on if you die soon. That's the answer, right? If you die soon and you don't have a clear estate plan designed and built for yourself that's reflective of exactly what you want, then there's a darn good chance that some bad things are going to happen to your wealth and potentially, things you probably even care more about your kids, like where your kids go and what happens if something happens to you when you're not prepared. That's the problem. And so procrastinating on your estate plan, and that's the biggest issue is being unprepared and then having something bad happen and everything just doesn't go the way you would have wanted it to go. And there's so many horror stories of that. From a pure financial standpoint, I guess the other thing that comes to my mind, Tyler, and I know you always have some other agenda bullets, but
please go.
The second one that comes to my mind is many times, especially in the state of Oregon and Washington for that matter, the estate tax consequence is it hits you at a very, very low threshold. So most of the country, the majority of the country, is tied to the federal government's estate tax restriction, which basically currently exempts about $12 to $13 million per person. So if you're married, 24 to 26 million, you can avoid estate taxes on. But in Oregon and Washington, that threshold is much, much lower. In Oregon, it's $1 million per person. So if you have anything over $2 million as a married couple or $1 million as a single person, you're going to be dealing with estate taxes, passing that wealth on to the next generation. And then as far as Washington, I think it's about $2 million a person. So it's maybe $2 million or $4 million if you're single or married. And that's with some proper estate planning to capture both the spouse's estate plan, credits, the $2 million apiece. But then it kicks in pretty high. You can see 10 to 15% of everything over that go to the state as a transfer tax. It's a tax on the right to transfer your wealth in that state to your own children or to your grandchildren. That's what they're taxing you for, and that's that's the way that works. Now, why are you potentially paying the price for procrastinating when it comes to your estate planning? With regard to that, well, if you had a better plan in place where you were able to legally shrink your estate prior to dying, you would have had potentially a significantly lower transfer tax or estate tax, also known as a death tax, that would have applied to your kids as far as taking that money away before they received it. The other scenario is a lot of times people will use life insurance to pay that estate tax burden. And if you're going to strategize with life insurance to pay that burden, which is a very cost-effective and tax-efficient way of considering doing that, if you're going to do that, then the younger you are when you get the life insurance policy, the more death benefit you get, or the lower the premium is for the death benefit you need. And therefore, it is directly cheaper, literally year by year. Every single birthday gets more expensive for you to delay that decision to do estate planning if you're going to use life insurance to take care of your estate tax planning tax needs. So, anyway, those are the thoughts that kind of come to mind. What do you got for our agenda bullets today?
No, I think that's great. And the first bullet is probably what a lot of our listeners are saying to themselves right now. Well, this doesn't apply to me. You know, I'm just right out of college. I'm a single person. I'm just renting an apartment. I've just started my new job. Like, why do I need this? Or maybe it's somebody, they're like, we're barely making ends meet with, between the two members that are running the household, and they have a kid or a couple kids and, a couple dependents. And they're like, there's nothing that we have to really be worried about passing on because we don't have a lot to pass on. That is the wrong assumption to make.
Fair.
Your estate plan is not just what you have and who it goes to. The most basic form of an estate plan is having a will, your last will and testament. And that not only says who gets what if eventually you pass away, but also who takes care of my children, who, if I become incapacitated, who's going to make decisions for me from a healthcare standpoint, things like that. And those things often are overlooked, which is why I wanted to talk about this from, it's not the more wealthy you are, the more applicable this is to you. That might be a certain degree where, yes, the more stuff you have, the more this is applicable to you, sure. But I think everybody needs to look at their estate plan regardless of what you have and how much you have and how old you are and all that stuff, and just understand it. I mean, do you have a 401k? Did you get married? Have you updated your beneficiary since you got married? All that stuff. These little things that often get over-missed, or you kick the tires on wanting to do something about it, can have significant implications if if something does go drastically wrong. So,
well, what Tyler just alluded to is so on point. And we've heard these horror stories many times. As financial advisors, of course, we get exposed to these stories more often than you do as a member of the general public. But fundamentally, if you've ever been divorced, if you've been divorced, there's a good chance that your ex-spouse was your beneficiary on your retirement account. And if you have not updated your beneficiary to reflect who you want to get the money if you pass away, we've seen scenarios where people have remarried, they've been remarried for years, had kids, and they never updated the beneficiary, and then one individual passes away and money gets left behind to one of their largest assets to an ex-spouse who has not been in the picture for decades. And that there's no way to reverse that once you die. The beneficiary typically is going to avoid probate. It avoids the ability to be contesting it. It'll automatically go to whoever you have declared. So in many cases, so you want to make sure your beneficiaries are accurate at all times. And not to say you can't give money to your ex-wife if that's what you want to do, or your ex-husband. I mean, if you want to give money to them, that's fine. You can give the beneficiary you make the beneficiary anybody you want. But if your intention is to give it to somebody else, make sure you update your beneficiaries to reflect where you want the money to go. And the other thing I would say is one of the exercises, and for those of you that have been longtime listeners, I think we should have that whole long-time listener, first-time caller. If you haven't been a first-time caller yet, you should call us at 503-579-1000 and book a conversation. But for any of you long-time listeners, no-time callers, you should drop us a line.
Absolutely. Or give us a like or something on YouTube.
Something.
Come on.
Please. Anyway, we're just talking to ourselves here. We have no idea who's listening.
That's true.
That's just the way it goes. Yeah. Now I'm distracted. Where was I going with this? Let's see. Beneficiaries, efficiency, passing assets on.
I totally derailed you. I'm sorry.
No, it's all right. No. Making sure your beneficiaries are updated. It's fine. I'm sure it'll come back to me.
It'll come back. Yeah. Yep. Let's go through some of the talking points. How about that?
What do you got? What do you got?
Well, the first was estate planning is not just for the wealthy, so I think we hit on that totally.
I remembered.
Boom. Okay.
Just like that.
What is it?
Sometimes you just got to take a drink of a Snapple, apparently, and they're not sponsoring us yet.
That'd be cool.
That would be
Snapple.
Cool. Snapple, please sponsor us.
Yeah.
Anyway, going to see, and then I forgot it again. No, it's going to come back.
Take another snip
the snip of the Snapple, and right there, like right on the tip of my tongue, just like the Snapple was.
Okay.
So as far as every January, I know for those longtime listeners, you may have heard me say this before, but I also have heard that psychologists have said the average human being needs to hear something 7 times before they remember it. So if you haven't heard me say this 7 times or more, then you probably still need to hear it again. So I'm going to tell you again. Every January, I go sit down, I print out all my legal documents, all my estate documents, the will, the advance directive or healthcare power of attorney, the durable power of attorney, the living trust. In my case, I have a living trust. If you have a living trust, you'll want to make sure you have that available to yourself as well. and any other legal documents that are going to be reviewed in the event of your passing. And I go and I put my AirPods in that are noise canceling. I'll sit down at Starbucks. Most of the time, that's where I'll go do it. I'll write down notes, and I'll just say, if this is the year I die, is everything going to go the way I want? And I read the documents. And if the answer is yes, then I don't worry about it for another year. I put them away and I know I'm good to go. And if the answer is no, or I don't know, then I tweak it, fix it with my attorney, update it, and then everything's going to go the way that I want it to go, and I don't worry about it for another year. The biggest sign that you're probably procrastinating on your estate plan and you need to do something about it is that little needling thing bugging you in the back of your head. If you have something bugging you or you're like, oh, I don't know, I should probably do that. If you're judging yourself and saying, I should probably do that, then you need to take care of that. You need to take care of that. Because if you knew that was clean, you knew you'd reviewed it within the last 12 months, you knew you felt good about it no matter what, you wouldn't feel that feeling of guilt that is sitting there resting on your shoulders or in the back of your head or wherever it is for you. And that's probably the best indicator that you maybe need to do a little bit of work on your estate plan. Yeah.
And just remember that not having a plan is a plan. It's a plan that the state that you live in gets to decide for you. Mm-hmm. So you have to decide, hey, I live in X, Y, or Z state. I'm okay with them deciding who gets what, where my money goes, who makes these decisions for me. But I have a feeling that 99.9% of our listeners are going to say, no, actually, I want to make those decisions myself. And if that's the case, this podcast is applicable to you.
That's right. Actually, if you've ever heard the term intestate, that is an interesting word. That's what Tyler's talking about.
Yep.
Every state has a plan for you. And when you pass away and don't have a will, then you've died in what they refer to as intestate. And fundamentally, the state has a will for you, and they will decide exactly according to their laws who gets what. And and that's not usually 100% aligned with the desires of every single person who lives in the state. So if you want to control where your stuff goes, both your assets and your valuables and your children, then it's on you to make sure you have a document that's compliant, that's legal, that's valid, that says what you wanted done, and that's all we're talking about. So,
yep.
What else you got for us? What else on our list?
The next one was wills versus trusts. What's the difference? So I feel like we've talked about this before in another podcast, and that makes it.
Yeah, I don't want to expound on it at a great length, but bottom line, wills versus trusts. A will is going to be so. First of all, I got to give the disclosure. I'm not an attorney. I cannot give you legal advice. So this is our understanding of wills versus trusts. You should Google it, ChatGPT it, whatever. Talk to your attorney, verify and validate the accuracy of this. But my understanding of wills versus trusts is that wills go through probate. They still go through probate. Probate is Latin for the word to prove. The purpose of probate is to prove the validity of a will, and a will is public, so it's something, because it goes through this public probate process, anything that's in the will is something that the public can see, and the public can then contest. And if they contest it, then it goes into court and can take a very long time and cost a lot of money and postpone the distribution of assets. Also, the will, from what I've been told by previous attorneys that I've spoken with, is the only instrument that can actually determine the guardianship of your children that you want to pass it on to. You can't pass on guardianship in a trust. The trust is designed for assets. The will is designed for your final wishes. So the guardianship of your children will always be something that's publicly visible if you put it in a will, and then it's also something that's up to contesting, so people could contest that. So make sure you clearly indicate exactly who you want to be the guardian, make sure they've accepted it, and make sure that you've documented that accurately. If you do have minor children that or other minors that you take care of, you might have minor grandchildren or even an adult child who's a special needs child who's dependent. The point is, any dependent who is relying on you, you got to have a plan for them if something happens to you, and that's what that guardianship can take care of. The trust can avoid probate, but the biggest mistake I see with people who create trusts is a lot of times they'll create a trust and they don't put anything in it. So just because you create the trust doesn't mean that all your stuff is magically in the trust. You have to change your ownership and/or change your beneficiaries of your assets in order to make sure they're in the trust, if you want the rules of the trust to apply to your assets upon your passing. So another missed step that we often see. I think that's
a good point. And I think most people miss that because it's not like a layup to do that. It's more of like a 3-pointer sometimes. It's not like you're shooting from half court, but it's like a 3-pointer if we're talking basketball references here, to move stuff into the name of the trust. It takes a little bit of work. Like your house. A lot of people are like, well, I want my house to be in the name of the trust. And it's like, well, you got to go to the county. You got to update the deed. That takes some time. You got to go back and forth. You got to pay to make the change. And that's why you should work with a good attorney, because they will help you with a lot of that stuff too.
That's right. And if you need a good attorney and you're local here in the Portland area, we have some excellent attorneys we can refer you to.
We do.
So just reach out to us. We can connect you with some people.
Yep. What are some of the essential documents everyone should have when it comes to their estate plan? So, we're calling people out for procrastinating on their estate plan. They're like, well, what should I get, guys? And I think we've already hit on maybe one or two of them, which is your basic last will and testament. Depending on the complexity of your situation, you might want power of attorney. So if something happens to you and you need somebody to make decisions on your behalf, or whether nothing happens to you, but you still want people to make decisions on your behalf now, if you have a situation that calls for that, a power of attorney, whether a durable power of attorney or a general power of attorney or all kinds of different power of attorneys. But basically it just says, I give this other person the power to make those decisions for me, and whether that's now or whether a certain event happens or otherwise. The Advanced Healthcare Directive, which I think you mentioned earlier. So that's if something happens to you and somebody has to make healthcare related decisions for you.
All that life support stuff, that's tough.
This is a tough one.
The whole point with legal documents is there's going to come a time when you're not there to answer the question of what to do with your stuff, or the things that you care about, or yourself, what to do with yourself. And if you can answer that question in advance, that's what the legal documents do. It just documents your answer so that when people are trying to do what you want done, that they know what you wanted done. And if you don't write that down somewhere, then nobody knows what you want done. And therefore, they're going to do what's they're legally required to do, even if it's not what they want to do, even if it's not what they think you wanted done. They don't have the freedom to just do whatever they want, or even what they think you would have wanted. They have to follow the law, and you get to dictate however what you want done. And it really is your last ability to communicate that while you have your full cognition and full power and mental capacity. So
Yeah, that's well said. Beneficiary designations.
Yeah, big deal.
We
talked about it
these
previously. Make sure you update those. Yep.
Those are huge. Think about all of your retirement accounts, your non-qualified investment accounts, life insurance policies, bank accounts. You can put beneficiaries on bank accounts. Usually it takes an additional step or two with your bank, but they have provisions where they can add people on there. So if anything happens to you, that money can be accessed by whoever you have named. And like Tim mentioned earlier, a lot of the times those beneficiary designations, most of the time, will supersede what your will says or what your trust says. And that's often overlooked. I was talking to a client today who didn't realize that, the beneficiary designation takes priority. And if those aren't in line with your estate planning documents, you could spend thousands of dollars to create a nice will that's totally tight and dialed in, and a trust that's like super comprehensive and awesome in your mind. But if your beneficiary designations don't align with those legal documents, it's all moot. It doesn't matter. The money's going to potentially go to somebody you don't want it to go to.
That's exactly how that ex-spouse stuff happens. You may have updated a will and a living trust and all this stuff with your new spouse and your kids with them and everything else, and you're planning on trying to do this. And then, because you didn't change the beneficiary on that account, the beneficiary will often trump the will or the trust documents, and you've got to make sure your beneficiaries and ownership are in line in addition to your documentation.
Yeah. The last bullet point I had here was planning for blended families and second marriages.
Yep. I mean, we touched on a few of the things there, but it is one of the other phrases I say a lot of times to my clients as they're trying to decide who to leave money to. Like, I've got clients that'll come in and they're in their late 60s or early 70s, very common. They're curious about their estate planning documents, and they may have 2 or 3 or 4 children. And some of their kids might be doing really, really, really well, and some of the kids maybe not be doing as well. And they're feeling like, they want to leave money equally because that's what they feel like they need to do, but at the same time, they feel like maybe some of the kids who aren't doing as well might need the money more. On the other hand, they feel like maybe the kids who are doing better might do better things with the money. And one of the things that I'll often say is that fair is not necessarily equal. And it's up to you, when you own all the assets, to decide what fair is. You get to decide how you want to allocate all of those resources, and maybe fair is equal in your case. Maybe it's not, and that's okay. you have the right to vote your dollars until the day you pass away or until the day you lose your financial or your capabilities, your mental capacity. So vote your dollars before you lose your mental capacity or pass away, exactly the way you think fair fits into your plan.
Yeah, well said. I think that's it.
Cool. No, that's pretty
that's
good.
It. We're
That's
about
tight.
20 minutes in, so that's good.
Yeah.
We kind of try to keep the podcast here. Any other final thoughts that you think we should mention? Again, with the topic being, are you paying the price for procrastinating on your estate plan?
Are you paying the price for procrastinating on your estate plan? Yeah, there we go.
Yeah.
Okay. Yeah. No, I mean, I think the issue is make sure things go the way you want them to go, and then generally speaking, there's 3 entities that will receive money upon your passing. There's your family, there's charity, and there's the IRS and State Department of Revenue. And you're going to divide up the pie to those 3 parties upon your passing. And if you do a good job, you can make sure that the party you want to get the most money gets the most money, and the other parties get less. If you don't do a good job, it may go the other way. And that's really as simple as it is. Having a good estate plan is about you deciding who gets the money. And that's your decision, and you're right to do that. But if you neglect to exercise that right, well, somebody else will step in and do it for you.
Yeah. What kind of pie?
Oh, good question. I don't know.
Yeah.
Gosh, right now, I used to work as a DMO, dish machine operator at Sherry's Restaurants back when I was 13 years old, and many, many years ago now. And they had such good pies. I'm sitting here thinking about coconut cream. I'm thinking about chocolate cream pie. I mean, both of those sound really friggin' good right now.
Yeah, that does.
Yeah, I've never been much of a hot berry pie kind of guy or fruit pie kind of thing. Some people are really into that.
If I'm eating pie, I want it to be a little sweet. Yeah,
I like those cream pies, man.
Yeah.
Oh, that's good stuff. Thanks for that. Appreciate it. I'm hungry now.
you're welcome. All right,
Okay.
just the answer.
Yeah, go for it.
Okay, so we're going to do the just the answer here. Topic of the day was, are you paying the price for procrastinating on your estate plan? Tim and I talked about a few different things. We, definitely listen to the full podcast, please, if you want to get all the nuts and bolts. But some of the main topics we talked about was why estate planning is not just for the wealthy. Estate planning really has a role and a place for anybody. If you have any amount of money, frankly, even if you're negative net worth, estate planning is still very important. We talked about why that makes sense for those people. It can make more sense for you the more money you have, but everybody should at least understand how estate planning ties into their life and give consideration to it to make sure that you're not missing anything, no matter what stage or phase of life that you're in. The other thing Tim talked about was wills versus trusts. What's the difference? So the wills and trusts, the terms get thrown around often. They work cohesively together a lot of the times to achieve similar goals, but they also work differently to achieve different goals. One of the main things was wills are your most basic form of estate planning. That's the most common. That not only helps make sure that money goes to who you want it to go to, it also helps to decide who gets guardianship. If there's any dependents in your life and you want to make sure that they have proper guardianship, if you pass away. Also talked about healthcare decisions. If you're not able to make those decisions for yourself, some of those legal documents can help make those decisions for you. But the main difference between the two, as Tim talked about, based on our interpretation of legal law and our understanding of how these things work, was wills are subject to probate, which means everything is public information, still has to go through the whole probate process. Trusts, if designed properly, can avoid that whole process and be more private and more streamlined, if you will. We talked about the essential documents everybody should have or everybody should know about. One of those is the will. One of those was the power of attorney. The other was the advanced healthcare directives. And I am missing if we talked about a fourth.
We touched on briefly a living trust, which
Living
the
trust,
benefits
yeah.
of a living trust, which we didn't expound on much, but avoiding probate. And that could be particularly valuable if you have real estate in multiple states. Imagine going through probate in every one of those states, because every state has their own probate. So if you have a living trust, you can title the real estate from all those states into the living trust and ultimately pass those assets on a lot cleaner, avoiding probate and keeping the expenses and administration down on your estate.
Yep, thank you for that. Beneficiary designations. We talked about beneficiaries, how most of the time your retirement accounts will make you choose at least one beneficiary to put on them. Other investment accounts Sometimes you don't have to choose, but it's usually in your best interest to put at least somebody on there as a beneficiary. Life insurance, your 401k plans, even bank accounts, all that stuff can usually have beneficiaries added to make sure that those assets go directly to the people or person that you want it to go to. So make sure that your beneficiaries are in line with your more comprehensive estate plans. Just because your will or your trust says one thing doesn't mean the beneficiaries are going to align with that. They have to all be cohesive, or things can potentially not go the way you want them to go. The last thing we talked about was blended families and second marriages.
A lot of ground here.
Yeah, we sure did. We hit on this one a little bit. I would say these are more complex issues. I would definitely consult a professional legal attorney, something like that, if you have a situation like this where it's a blended family, second marriages, and the more complex it gets, the more you're going to want to tie in those other people that have this experience and exposure to these things that can make sure that you don't have any missteps.
Yep. There are a lot of things to pay attention to there too. And again, I guess going back to my comment about equal versus fair,
Yes.
especially in blended marriage situations, a lot of times the spouses may retain their assets separately. Other times they pool them together, and that's okay either way. Again, an example of it. There's no right or wrong way to do that. You just have to decide what you want to do in your relationship, where you want your assets to go, and then the things like marital trust can come into play. There's lots of other estate planning strategies that can come into play when you're dealing with combined families, second marriages, things like that. So
Yeah, well said.
cool. Well, that was a good summation.
That was great.
Well done, Tyler.
Thank you. I learned from the best.
Oh, please.
Yeah.
Well, it's I continue to learn from you as well.
I appreciate it.
It's a pleasure. Well, that's where are we going now?
We're going to trivia.
Of course we are.
You ready for this?
I'm
We're
ready.
going to tie it into the topic of the day. Okay, trivia question today. Which historic document signed in 1215 is often credited with inspiring modern wills and property rights as we know them today?
Well,
I'm just laughing at the 1215. Like, I can't even imagine what life was like in 1215.
I know, 1215. It's so funny because there's like I don't know, this is tickling my memory from something, and I know I probably recognize it when you give me like the multiple choices or whatever, but and I feel like an idiot if I say the wrong thing. I mean, some historian's going to hear this thing and be like, "Dude, Tim, you're an idiot. That talks about this, and it was in this year, and it's not this." And I'm like, "That's very possible." But the phrase Magna Carta comes to my mind. I don't know if that's what that is or not. But what do you got?
No, the Magna Carta is correct.
Oh, there we go.
The Magna Carta is correct.
Magna Carta was it. Yes,
I mean, the multiple choice that ChatGPT gave me is pretty terrible. So ChatGPT, if you're listening, terrible.
So
it was the
really
Constitution.
The Constitution, clearly not that.
The Mayflower Compact.
Oh, yeah, not that either.
Nope, the Magna Carta and the English Bill of Rights.
English Bill of Rights. Yeah,
it
could have been the Magna Carta is what I was
Anyways.
feeling like. I thought that was what it was called.
That was great. Nice work.
Look at that. 1215. I couldn't have told you that, but now I can.
That's awesome. Very cool.
All right, thanks for the trivia.
Yeah.
Nailed it. Awesome. We'll see.
Where do we go from here?
I think that's about it. Other than if you are a long-time listener or no-time caller, you should call us.
Yeah, you totally should.
At 503-579-1000. And actually, if you haven't looked at our website lately, we just updated our website.
Yes.
You should totally check it out. In fact, we've updated it to be much more consistent with what we're currently communicating to our clients. So the website is clearfp.com. So clear, C-L-E-A-R, F as in Frank, P as in Peter.com. Yep. And we talk about the 5 different kinds of accounts that we work with. Then we've assigned colors to them, blue, red, yellow, green, and orange. And we talked about some of that in our podcast previously. But if you want to learn more about the kinds of things we do, the kinds of work that we do with our clients on a regular basis, go to that website. Check it out.
Yeah, huge props to the team. It looks really
sick.
Yeah, for lack of a better term.
Well done.
Yeah.
All right. Until next time, thank you very much for joining us on Clear Money Talk.
Tim Clairmont and Tyler Andrews are investment advisor representatives offering securities and advisory services through Ceteri Advisor Networks, LLC, a broker, dealer, and registered investment advisor, member FINRA SIPC. Ceteri is under separate ownership from any other named entity. The views depicted in this material are for information purposes only and are not necessarily those of Ceteri Advisor Networks, LLC. They should not be considered specific advice or recommendations for any individual. For a comprehensive review of your personal situation, always consult with a tax or legal advisor. Neither Ceteri Advisor Networks, LLC, nor any of its representatives representatives may give legal or tax advice. All investing involves risk, including the possible loss of principal. There is no assurance that any investment strategy will be successful. Examples referenced are hypothetical only and do not represent the actual performance of any particular investments. Converting from a traditional IRA to a Roth IRA is a taxable event. A Roth IRA offers tax-free withdrawals on taxable contributions. To qualify for the tax-free and penalty-free withdrawal or earnings, a Roth IRA must be in place for at least 5 tax years, and the distribution must take place after age 59.5 or due to death, disability, or a first-time home purchase up to a $10,000 lifetime maximum. Depending on state law, Roth IRA distributions may be subject to state taxes. Distributions from traditional IRAs and employer-sponsored retirement plans are taxed as ordinary income and, if taken prior to reaching age 59.5, may be subject to an additional 10% IRS tax penalty. Investors should consider the investment objectives, risks and charges, and expenses of mutual funds and ETFs carefully before investing. The prospectus, which contains this and other information about the funds and ETFs, can be obtained directly from the company or from your financial professional. The prospectus should be read carefully before investing or sending money. A diversified portfolio does not assure a profit or protect against loss in a declining market. Dollar cost averaging will not guarantee a profit or protect you from loss, but may reduce your average cost per share in a fluctuating market. Investors cannot invest directly in indexes. The performance of any index is not indicative of the performance of any investment and does not take into account the effects of inflation and the fees and expenses associated with investing. Although it is possible to have guaranteed income for life with a fixed annuity, there is no assurance that this income will keep up with inflation. There is a surrender charge imposed generally during the first 5 to 7 years or during the rate guarantee period. There is a surrender charge imposed generally during the first 5 to 7 years that you own the contract. Withdrawals prior to age 59.5 may result in a 10% IRS tax penalty in addition to any ordinary income tax. The guarantee of the annuity is backed by the financial strength of the underlying insurance company. Investment sub-account values will fluctuate with changes in market conditions. An investment in a variable annuity involves investment risk, including possible loss of principal. Variable annuities are designed for long-term investing. The contract, when redeemed, may be worth more or less than the total amount invested. Variable annuities are subject to insurance-related charges, including mortality and expense charges, administrative fees, and the expenses associated with the underlying sub-accounts. Investors should consider the investment objectives, risks, and charges and expenses of the variable annuity carefully before investing. The prospectus contains this and other information about the variable annuity. Contact Clear Financial Partners at info@clearfp.com or 503-579-1000 to obtain a prospectus, which should be read carefully before investing or sending money. The cost and availability of life insurance depend on factors such as age, health, and the type and amount of insurance purchased. Before implementing a strategy involving life insurance, it would be prudent to make sure that you are insurable by having the policy approved. As with most financial decisions, there are expenses associated with the purchase of life insurance. Policies commonly have mortality and expense charges. In addition, if a policy is surrendered prematurely, there may be surrender charges and income tax implications. Clear Financial Partners is located at 15573 Bangi Road, Suite 100, Lake Oswego, Oregon 97035. For more information, please call us at 503-579-1000.